You all know why you're here. It's Legally Speaking, the inside legal tips for first-time buyers or sellers of New York homes. As you can see from the slide that's up, our speaker is Zahava Schechter. She's an attorney and she's been in the New York board for more than 30 years. Her law practice is concentrated in estate planning, administration and litigation, elder law, real estate law, and business law on Long Island and New York City. One more thing I just want to share is she's going to speak for about 20 minutes. If you have any thoughts that come into your mind, you could enter it in the chat, but there will be a Q&A in the end that we'd love for you to all participate. And it looks like I'll be able to unmute you so that you can do that. So join me in welcoming Zahava Schechter to the Great Neck Library virtually. Go ahead, Zahava.
Thank you so much. Good evening. And I want to thank the Great Neck Library and Donna for presenting this informative program, which I hope you will find interesting. I just want to make a note from the beginning that I'm not going to give any specific legal advice, but if you have general questions, I'm happy to answer them. And I hope everyone is well today. If you have a question, as Donna said, at the end, you can ask me, or if you want to, you can put it in the chat box, or if there's something more private, feel free to contact me afterwards. I'm happy to speak with you at no cost. So I'm an attorney with more than 30 years of experience. As Donna said, I concentrate my practice in real estate law, estate planning and administration, estate planning being helping people and individuals prepare for incapacity or death. Administration is helping family members after someone has passed. And I also practice business law, setting up companies, corporations, etc., also dissolving them. I also run a podcast, and you might be interested in It's Everything Legal on Long Island, the LI Law podcast. And you can hear me on Apple or Google or wherever you get your podcast. So I hope you enjoy. I want to start, I know we're in Nassau County, but I want to start with the fact that if by any chance there is a first-time home buyer here, and if you are looking in Suffolk County, not Nassau County, there actually is a down payment assistance program up to $15,000 to help first-time home buyers who meet certain income eligibility guidelines. And it's a loan for a certain period of time, usually 10 years, and then it turns into a grant if you're still living there. Unfortunately, at this point, Nassau County is not offering such a program, although it has in the past, and it may again, now that we have a surplus and in addition, money from the CARES Act, who knows when this program will start up again in Nassau County. But if in the meanwhile, if you're looking in Suffolk County right now, the deadline for submitting your application is April 15th. So that's the website, something to keep in mind. I do want to talk to those of you who either are owners of property in Nassau County, or maybe you're in the process of becoming an owner. I encourage everyone to file a tax grievance. What is a tax grievance? Nassau County assesses your property at a certain value. That is not necessarily what someone would offer you for the value for your property, excuse me, but it is a certain valuation which Nassau County sets in comparison to like-minded, similar properties, we call them comparables, similar properties in your area. If you do not grieve, meaning appeal, whatever that valuation is, I want you to know you're going to be paying definitely more than your share of taxes. I cannot promise you that if you grieve your taxes that you will pay less, but I can tell you if you do grieve, and that's what we call it, the grievance process, and if for whatever reason Nassau County does not lower your assessment, you don't pay anything for it. I don't do this work, but if you have questions and you want to ask me about it, feel free. I would say to you, you have until April 30th if you own a Nassau County property between now and then, and there is absolutely no downside to grieving your taxes. So I strongly recommend everyone do that. I want to talk about the type of property, because when people say, oh, I'm buying a house or a co-op or a condo or a commercial property, we need to know what we're talking about. So I want to start with real property. And this is going to be, obviously we can't do everything here, but it'll kind of be a primer, especially for a first-time home buyer. If you've done this process before, either buying, selling, it may be a little simple for you, but I hope there's something here for you as well. Real property is defined as something attached to the land, like a house or a building, whether commercial or residential. It also includes condominiums. And that's important because in any of these types of transaction, buying or selling, what you get in exchange for the money that the buyer pays, you get a deed. A deed is a legal document by which ownership, that's called title, ownership of property is transferred. On the other hand, we also have cooperative units. Now, what's interesting is people say, oh, I'm buying a co-op. Co-ops are generally a little less expensive than condos, and they have different rules. The most important thing to know in the differences, actually, there are two things. One is the difference between a co-op and, let's say, a house or a condo is you don't get that deed. There is no deed with personal property. What you get instead is a share certificate that you own a certain number of shares in the cooperative corporation, just the same as if you bought shares of IBM, Coca-Cola, or any other corporation. The other thing I want you to think about when you buy a co-op is it's not for you to decide as the owner of a cooperative unit. It's not for you to decide who buys it or can you make changes to the unit or anything involving the structure of the unit. Rather, it is up to the co-op board. So when you buy a cooperative unit, you really are bound by the rules of the cooperative as well as the decisions of the cooperative board. I always say to my clients who buy co-ops, as soon as you can, try to run for the board. It's hard to get to become a member of the board. However, they carry a lot of weight and something I recommend. So let's talk about the transaction because I get calls all the time from people. I've never done this before. I'm a first-time home buyer. What happens? How does it work? So I want to give you a little bit of background so that you're prepared. The first thing as a purchaser you do is you go to visit the house, condominium, or cooperative unit. Now, usually that's via a real estate agent. The agent shows you the property during the greater times of COVID, the times when there were more people who were ill. Really, there were very few in-person viewings of units or co-ops or houses, et cetera. Now it's much more open, although you do need the appointment to go in and see. But I see, generally speaking, anyone can see a property that is for sale. If you like the property, you make an offer. Now, I will tell you, it is a seller's market now. Anyone who says otherwise is not watching what's going on. For every property, there are many, many offers. And usually there's a bidding war, which definitely drives up the price, even beyond that which the seller is asking. I also see higher down payments being offered. So if you're working with a realtor, and I strongly suggest you do as a buyer, definitely, you need to talk to that realtor about what the market is really showing, how much you should be offering for that property and how much you should be putting down. Your choice of realtor is very important. Just like property, location, 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 pick a realtor who is knowledgeable about your area, knowledgeable in that town, whether it's Great Neck or any other town, and is familiar with comparable properties. The purchaser's offer is then hopefully accepted by the seller. Again, there's a lot of competition right now. I'm not trying to scare anyone off. I'm just telling you how it is at this moment. I'm not sure how long that will be. Then it is very important for the purchaser to arrange for a home inspection. That usually costs $500 approximately. And a lot of people say, oh, Zahava, I'm going to skip that because maybe as a first-time home buyer, I don't have a lot of money, or I can see everything is good. Really? I don't know about that because I know I'm a lawyer. I'm not an engineer. I'm not an inspector. I can't tell if the electricity is working, is not working. Okay, you can flip the switch, but there are things like the roof and the plumbing and the electricity, et cetera, that a professional engineer who is a home inspector can see that we cannot. And this is very important because you may find either there are problems within the house that you can't live with, or there are problems you can live with, or maybe there are no problems at all. However, with a home inspection, you are definitely a lot wiser. So I recommend to all purchasers, even on a co-op, to do home inspection. The seller's attorney prepares the contract of sale. The attorneys on both sides negotiate the terms of the contract. As an attorney, my job is to represent my client, whether as seller or buyer, and to do the best I can to protect my client and make the best deal I can. So we're going to continue. The purchaser signs the contract of sale first and provides a down payment check payable to the seller's attorney as escrowee. Now, I have here usually at least 5 to 10% of the purchase price. I am seeing more now, but I would say if you don't have at least 5 to 10% of the purchase price as a down payment, meaning at time of contract, to say, okay, I want to hold this contract and here's the money I'm giving to the seller's attorney to hold in escrow, meaning to hold pending the culmination of the transaction. I don't know how seriously a seller will consider your offer, but again, that's something you can discuss with your realtor or your attorney. The seller signs the same contract of sale, and we call that a full execution of the contract. The down payment is deposited into the seller's attorney's escrow account, and then everything starts. Until you have that fully executed contract, there's nothing that can happen. You can't get a mortgage. You can't start finding out about the property. So now the real excitement begins. And I usually find my first-time home buyers in particular very excited at this point. We order the title report if it's a house or a condominium or even a commercial real estate building, or a lien search if it's a cooperative unit. And the purpose of this is to find out who really owns the house. So Donna from the Great Neck Library can tell me she's the owner of the house. But if it turns out when we do the, and no aspersions here on Donna, if it turns out when we do the title report that in fact Donna doesn't own, but I see there's a Sophie here, Sophie owns the property. So why would I even give any money to Donna in this process? So you want to make sure, you know, a house is probably one of the most expensive, if not for most people, the most expensive investment you're going to make in your lifetime, whatever kind of home you live in. So why not make sure that in fact the ownership you're getting, the title you're getting is good?
Zahafa?
Yes.
Yeah, I just want to pull up a question that someone asked so we don't get lost. Rachel Smith asks, after the inspection, if something is wrong with the house, who should pay for it, the buyer or the seller?
Okay, so that's a
We
great
have a
question.
great answer for that. Yeah.
That's a great question, and I'll stop and then we'll come back here. So the first question, when you do an inspection, you need to think to yourself, if there are minor problems here, whether aesthetic or other, if there are minor problems, am I willing to take the property as is? Because I have to tell you, most sellers are not really interested in putting more money into the house. Having said that, if it's a major problem, there are termites, there's wood boring, insect damage, or the plumbing is faulty, or the roof is leaking. I'm talking major stuff, major things. The seller is probably going to remediate or repair or take care of it. If it's something like, you know, I really don't like the faucets on the handles, or, you know, on the doors, or I don't like the way the shelves, the built-in shelves are, something that, okay, you don't like it, but it's not going to lead to either an electrical, plumbing, there's no major problem in the building, chances are the seller will not fix it, remove it, etc. So it's kind of hard to say, Rachel, in all circumstances, this is what it will be, but I will say this to you. The more serious the problem, including lead, by the way, lead remediation they have to take care of. And I recommend to all my buyers to look for lead as well, especially if you have little children who are going to, you know, eat the walls or whatever. The more serious the violation, the greater the chance that the seller will have to do something. But just know for yourself that if there's nothing really serious, but something that you would like to change, chances are the seller will not pay, and you'll deal with it after you purchase the home. Okay, so hopefully that answered. If not, I'm going to go on and you'll ask me at the end. Okay, thank you, Rachel, for that question. So now that we're in a fully executed contract, right? Both sides have signed, and we're getting our title report. That takes time. Now it's time for the purchaser to apply for a mortgage, if applicable. We're going to talk about all cash deals versus mortgages later. But what I want to say here is, if you are applying for a mortgage means you don't have the cash to pay, so you're applying for a loan, whether from a commercial bank or from a private bank or a mortgage broker. You should have all your papers ready, your W-2s, your tax forms, your bank statements, everything financial that will show that you are a good risk. You're a good credit risk. You'll pay back your mortgage, because the more prepared you are, believe me, the smoother the process for you as a purchaser, in particular, as a first-time home buyer, to qualify for the mortgage. Any title objections are clear. What's an objection? Well, let's say Donna transferred the property to her daughter, Sophie. I'm sorry, I'm picking on these names again. Sorry about that. And for whatever reason, and now Sophie is a seller. And for whatever reason, that deed, remember the deed is the document which conveys the ownership. That deed from Donna to Sophie was never recorded. That is an objection. We've got to make sure the chain of title, A selling to B, who sells to C, who sells to D, that all of that is clear. By the way, if you own property and you want to look for yourself and see what is recorded against my property, I don't know if all of you know this, now if you're in Nassau County, the Great Neck is in Nassau County, you can go to 240 Old Country Road, and that is the Nassau County Clerk's office. They have a land registry office. You bring your address as well as your section, block, lot, and they'll tell you. It may take a while, but they'll tell you how, what liens there are and whether your property has whether there are any objections. So that's something to think about, especially if you're not sure of the history of your property. The mortgage company, remember, the buyer applies for a mortgage. The mortgage company needs to issue what's called a mortgage commitment. Now, that's not final. That's not the mortgage. That's not JP Morgan saying, or Chase saying, okay, great, Donna, we have the mortgage for you. That's saying, everything else being equal, if we continue to look at your application and you've been honest all the way through, then we're going to fund your loan. But you're still not there yet. It's a long process. The title company then has to clear your file to close. So if you recall, I'm going to go back here. If you recall, we had to order the title report to make sure that Donna was the owner and not Sophie or not Aaron or not anybody else. So now the title company's gone through all the objections and all the liens and all the judgments and everything. And it's really a very thick report and says, good, you're good to go, buyer. Very good. By the way, the title company is the buyer's title company. We're going to talk about this later. Remember that, please. The title company is, the responsibility is to the buyer, not the seller. And we'll talk about why that is. The mortgage company then clears the file to close. That's different from a mortgage commitment. That is clearance. That's, let's set the closing date and go. The closing documents are prepared and we get to the closing. That's what we call it here. In some states, it's called settlement. In some states, it's called other things. But here in New York State, we call it a closing. The seller gets their money. The purchaser gets title ownership. The real estate brokers get paid. Happy ending. That's what we like. Actually, real estate law is one of the nicest areas of law for attorneys as well, because usually, not always, the seller's happy to sell, buyer's happy to buy, everyone's happy. We hope. Okay, so I want to talk about this. We talked for a moment ago, I'm going to go back for a second, about how, about the title objections and how the purchaser's attorney orders the title report. So what I want to show you is Congress set up a law. This is a congressional law, RESPA, that a seller cannot require a purchaser to purchase title insurance from a specific title insurance company. The gist of this is the buyer picks the title insurance company. Why? Because that title insurance company is giving a warranty, a promise to the buyer that we've checked everything about this property. And in fact, Donna is the owner. And not only is Donna the owner, there are no liens, no judgments. She doesn't owe any money to the IRS. She's not on the Patriot Act list of, from Homeland Security. It's a very extensive list. She hasn't declared bankruptcy. She's up to date in her taxes, real estate taxes. It's a very, very thick report. And as a result, the buyer has to trust the title company. Therefore, the buyer chooses his or her or their title company. And that's why it's important. So I found this joke, and I think it's very important to bring humor into everything we do. And I thought this was interesting. Who needs a lawyer at the closing? This is what the buyer's saying. I saved legal fees, and the seller threw in 7 liens for nothing. So the joke here being, it's like penny wise and dollar foolish. If you aren't represented by an attorney, New York is an attorney-driven state. If you're not represented, you may end up with liens. A lien is a debt which attaches to the property, and it doesn't matter who the owner is. If I own property and I sell it and there are liens, there are debts against my property, and that's something you can find out at 240 Old Country Road in Mineola. If there are debts, that goes with the property. Even if I sell to Donna, Donna now has gotten my liens, and she can't say, oh, well, Zahava, those are your liens. No, Donna, we closed and you accepted the property with those liens. So it's very important to have a team working with you. The broker, the real estate broker, either a mortgage broker or a loan officer, and an attorney, all working together to make sure that you are protected. Okay, I want to talk about one other thing. Since we're talking about title, it's very important. Title means ownership. The difference between marketable title and insurable title. For a buyer, this is crucial. Marketable title means that Donna can sell to me. Donna owns the property. Market, meaning sale, right? Donna can sell the ownership to me. But insurable title means that the insurance company, the title insurance company, will insure the property. So, for example, if there's any question that Donna does not own the property and that Sophie owns the property, the title company will not insure the property. Even if Donna tries to sell to me, we could have a deed, no problem. I could give her money, but the title company will not insure that transaction. So it is so important to have both types of title, marketable title and insurable title. I'm trying not to get too much in the weeds, but I want to let both buyers and sellers, but certainly buyers, know these are pitfalls and they are not the same. Okay, so now let's talk about mortgage versus all cash deal. Does it matter if the purchaser applies for a mortgage or an all cash deal? Well, it certainly matters to the seller. And I'll tell you why. If I'm a seller and let's say Donna is my purchaser, and Donna says, Zahava, I don't need a mortgage. I'm going to give you, let's say in Great Neck, I'm going to give you $1 million for your house. And it's an all cash deal. Please, Donna, do not bring suitcases to the closing. You will bring a certified or bank check, but it's going to be no mortgage on the deal. That's what an all cash deal is. That seems to me pretty good. That means I don't have to put my property to the side waiting for Donna to get a mortgage. And if she cannot get a mortgage, she gets her down payment back. And I start from the beginning again. I have to look for another buyer. Then I start talking to Sophie and Aaron and everybody else. So an all cash deal means, Donna, you're stuck with me and you owe me that $1 million. And there is no what we call a mortgage contingency. I'm sorry if I'm going a little longer, but we're moving on. So for me as a seller, it's pretty good. The only problem is, number one, for Donna, she's stuck as a buyer. And number two, Donna says, well, seller Zahava, if I'm giving you all cash and you don't have the risk that I might not qualify for a mortgage, I'm going to offer you less money. So it's like a double-edged sword, but something to think about. Does the purchaser need a survey? Yes, yes, yes. If I represent you and you're the buyer and you don't get a survey, I'm going to ask you to write a letter saying, Zahava told me to get a survey. I chose not to do it. It's very important. The survey is a blueprint. It tells you for your whole property what's there. So maybe there's a dormer or an air conditioner or a fence or lots of other things which need certificates of occupancy or completion from the town of North Hempstead. And if you don't have those certificates on there, there's a problem. So yes, you need a survey, and that's all I'll say on that. All right, so issues to consider. I just want to say for all of these things, central air conditioning unit, shed, fence, many other things as well, certainly anything you build onto your house, you need permits. You need to go to the town building department. You need permits and you need certificates. If you're a buyer, and let's say I'm the buyer and Donna's the seller, and she has the central air conditioning unit and there's no permit or certificate. Why do I, as buyer, want that responsibility that I have to go down to the town and say to the town, all right, it's already there. It's now, I have to pay for that. I'm going to make sure that Donna, as seller, takes care of that and pays whatever fees and penalties are involved, and inspection and everything else. If you've ever dealt with the town building department, not always the easiest process. So I'm going to make sure that that doesn't become my headache. That remains the seller's headache. In addition, if you have fences on your property and they are not on the property line where they should be, your neighbor can now claim ownership of that part of the property. And here's another cute comic I found. I found happiness in my own backyard, but my neighbor claims it's on his side of the property line. Be really careful where your fences are. Make sure that you do not have what's called land out of possession, and watch out for these. We're going to talk about it. Watch out for open mortgages. You're the buyer. You want to take the property with no liens, nothing, clear, clean, no tax liens, no mechanics liens. A mechanics lien is, let's say a contractor comes and fixes the roof. I'm the seller and I didn't pay the contractor. So the roof is already there. What is the contractor going to do? Remove the roof? No. So the contractor puts a lien, that's a debt, right? A lien onto the property that I cannot sell the property without paying off that lien. Just so you're aware, list pendants. I am not only selling to Donna, but I also have a second contract to Sophie. And Donna finds out about Sophie and says, no, I'm filing what's called, it's Latin, lis pendens. No, Zahava signed the first contract with me. I don't care about other contracts. It's my house. So just be aware, if that happens, not a good situation. Money judgment. Let's say you owe someone money. You have a contract having nothing to do with the house, nothing at all to do with the house, but it's a personal debt to you. I have a contract, I didn't pay on it. Well, Donna, who is the creditor, can put a lien. She gets a money judgment from the court and put a lien on my house, even though it has nothing to do with my house. And that's a way for her to get paid too. Out of possession areas, we've already kind of talked about that. So now I want to talk about some myths. We're getting near the end, I promise you. And these are myths about selling your house. And these are things I hear from people all the time. So I figure if they're saying it to me, maybe you think it too or wonder about it. First of all, myth number one, if you're a seller or even a buyer, it doesn't really matter if all the town certificates are in place before you sell. Totally not true. Purchasers who need a mortgage must have everything in place, because otherwise the lender, the bank, whether it's Chase or Citibank or a private lender or a credit union, which is a great place to get a mortgage, etc., they will probably not clear the funding of the loan until everything is in place. The town requires it. Make sure everything is in place, especially if you're a seller. Do it before you list your property for sale. Second thing, any side deal you make with the purchaser is enforceable. Oh my gosh, I once had a seller, it's a true story, a seller who said, you know, it's true that the seller pays a transfer tax. I don't know if you know that. Just for the privilege of selling property in New York State, the seller pays in Nassau County 4/1000 of the purchase price. In New York City, it's even more. But in Nassau County and most of the state, it's 4/1000. So the seller actually said to me, we're going to put less money on the contract. So instead of $1 million, we're going to put 500,000. I'll get the 500,000 under the table, and I only have to pay the 4/100th transfer tax on the 500,000. Oh my gosh! Not only is that illegal, and I'm certainly not going to lose my license over it, but it's unenforceable. You can't. Whatever the contract says, that is what governs. Anything else is an empty promise. Okay. Then I have sellers who say to me when I represent sellers, buyers, I don't need to read the contract. Just tell me where to sign. I want to say to everyone here, if you are signing any contract other than, I guess on the internet, you agree to the rules, because most of the time we don't want to read the fine print. But if you're signing a contract of sale for property, whether to buy or sell, please read it. You're bound by it. Ignorance is not a defense. You're bound by it. Your attorney should be spending at least an hour going over every single provision in the contract to make sure you agree. Because maybe if you knew what was in the contract, you wouldn't agree. So please do not sign any contract without reading it. It is very dangerous. A signed contract means the deal's done. No, there could be all kinds of problems. Maybe the buyer doesn't qualify for a mortgage. There may be a problem with ownership, a chain of title. Who knows what the problem? There are many problems that it could be. And as a seller, you have to be careful, because during the period before the mortgage contingency expires, if there is one in the contract, your property is off the market. So I just want to say one thing on this. I'm going to move on to the next slide. If Donna offers me $500,000 today for my property, and we both sign the contract, and then tomorrow Aaron offers me $600,000, I cannot take, as a seller, I cannot take Aaron's offer, even though it's $100,000 more. I'm stuck with Sophie. I'm sorry, I'm stuck with Donna, because we have a fully executed contract. So be careful as a seller what you sign. Okay, so now some myths about purchasing a home. Purchasers need to prepare for the purchase only after the contract of sale is signed. No, I told you, get everything ready ahead of time. All your financial documents, be ready so that you can hit the ground running as soon as you have a contract and apply for your mortgage. There is no difference between a condo and a co-op. I go through this with clients all the time. I started to say to you, when you deal with a co-op board, your decision-making ability is in their hands. Also, you don't get the deed. You get that share certificate. You cannot close on the transaction once you get a commitment. You have to be clear to close. We kind of talked about that. I'm just moving quickly because I see the time. Here's another thing, just like the contract of sale, people say to me, lenders' documents are standard. I don't need to read them. Well, I will tell you, some documents are standard. Fannie Mae documents. I'm not going to go into which are and which aren't, but there are a lot that can be negotiated, including paying fees and all kinds of costs. And this is where an experienced real estate attorney really can guide you as to how to save money. Okay, I have to say this, it doesn't have to do with real estate, but I got to tell you anyway. In the past, let's say month, I have found for more than 25, 30 clients, unclaimed funds. Go onto this website. It doesn't cost you anything. Look up your name, your family's names, your friends' names, and you will definitely find people for whom New York State is holding money. This is called escheat, E-S-C-H-E-A-T. If money is not claimed within a period of time, New York State actually keeps the money. So you have nothing to lose and everything to gain, if only for the unclaimed funds. If you find them, I hope that you found this presentation interesting and informative. I hope during COVID you're staying well and safe. If you have a question, feel free to email me or you can call me. And there we go.
That's great, Zahava. There are lots of questions here. If I could just start.